Hello, my name is Tim Callgreen, Director of Civic Education at the Indiana Bar Foundation. And with me today, we have Judge Melissa May from the Indiana Court of Appeals. And we're going to have a conversation about organizing your mock trial case and case theme. Judge May has earned her undergraduate degree from IU South Bend and her law degree from IU School of Law, Indianapolis. She practiced law for 14 years before being appointed to the Indiana Court of Appeals in 1998. Judge May has been active in local, state, and national bar associations and bar foundations, including recently being named to the American Bar Association's Committee for Attorney Specialization. She has also just finished 3 terms on the board of directors at the Indiana Bar Foundation. Judge May has taught trial advocacy courses at the IU McKinney School of Law since 2004. So Judge May, it's great to have you talking with us today.
Thanks, Tim. Happy to be here.
So as mentioned before, we're going to be talking about case organization and theme. And with any procedure with mock trial, there isn't just one right way to do things, but we're going to have this conversation with you, the expert, on a way to help the mock trial team with this topic. So let's start with this. Why is case organization and theme important? Isn't just cornering a witness on cross and delivering that resounding closing argument more important?
You know, a lot of people really think that the most important part of a case is the opening statement, or the absolute best thing is a really good final argument. But if you don't know how to find the facts in the case and how to organize it, you're never going to get to that point. You're never going to get to where you're organized enough and know the facts well enough to deliver, a perfect opening statement, which a perfect opening statement doesn't exist, but a really good one, or a blistering final argument, unless you do the work ahead of time and really learn how to organize and go through and look deeply into the facts. You won't even get to the point where you can do that killer cross-examination.
Okay, so when you open up a mock trial case, you see all sorts of different elements in there. You've got the case background and those witness statements and exhibits and stipulations, just to name a few things. So what should somebody look at first and why?
You have as many different opinions as to what you should look at first as there are people actually trying to read the stuff. What I would say is start with what happened first. So whatever in the case happened first chronologically, I'd take a look at that. And if that is a summary of the case, I mean, I know sometimes they have a summary. Sometimes they'll have, in a criminal case, they'll have an affidavit of probable cause. You might want to look at that because that'll have a lot of the facts in it. And then you just kind of start going from there. I'd look at all the witness statements and what I used to do first when I first got a new case in was I just kind of skimmed everything and kind of took notes as far as what was there. So you've got the statement of so-and-so, you got the statement of this guy, the statement of that guy, the statement of this person, and kind of make a list of what all you have. And then kind of go back through it and make more notes as far as establishing a timeline. One of the things that's vital, and this doesn't make any difference whether it's civil or criminal, you need to develop a timeline in your case so you can have somewhere where you can go to look at to see exactly when this stuff happened, what was said to who said it, and where can you find that in the record. And the record, I mean, where in the witness statement? Was this in the probable cause? Was it in the officer's report? Was in it an investigator's report? I mean, where you can find that stuff is really important. Because even if you've got a small case file, you don't want to get in the situation where you're preparing for something or you're actually presenting and the judge or the other attorney says, counsel, where is that in the record? And you're going, I don't know. So if you've written it down at least once, you have a better opportunity to remember that in the future. So I don't think it really matters exactly where you start, other than making sure that you know what the timeline is in the case.
I was just going to say, so a timeline, a chronology is
Yeah.
a great starting point.
Yes, I think a chronology is really important in how you organize the case, because you have to start somewhere. You know, you have to start organizing your case somewhere. And I found it easier to go, you know, because we do things on a, you know, on a schedule. You know, our life goes around, you know, when school starts, you know, when, you know, spring vacation is, when fall vacation is, when all of this is. So I think that if you go by calendar and then chronologically, it's something we're used to. And so it kind of resonates with us as far as keeping track of things.
Great. So, what's the goal that somebody should have in mind when they're organizing their case? Isn't just the end goal, you know, finding the defendant guilty or not guilty? So, what should somebody be looking at when looking at the case?
Well, you know, attorneys will tell you that that they're interested in justice, and I think everybody is. But most importantly, lawyers want to win. I mean, that's true. You want to succeed. You want to win. You want to do the best for your client, regardless of whether your client's an individual or whether it's a state. Um, so I think the you know the importance of it is not just you know who was guilty or who is found not guilty. It is, you know, making sure that you comply with the rules of the system. So when you are organizing a case and preparing a case, the better prepared you are, and the more organized you are, the more likely you are to succeed in what you want to accomplish in that case.
And
Uh, and
ethics and a civility piece too. I hear that in what you're saying too.
Yeah, an attorney normally, if they are very well organized, they'll know pretty much whether the case is one that has a better chance of winning or has a better chance of losing. If you don't really get down and look at the facts of the case and figure out which facts are unchangeable, there are facts that are without change, meaning that there's never a question that the car accident happened at 3:05 p.m. on August 4th. I mean, that is set. That will never change. So there are certain facts in the case that will never change, and you have to make sure that you know those so that you can build your case around those facts that you know aren't going to change, because there are a lot of things you find out in a case, such as what somebody said to somebody else or somebody's opinion, that are subject to change. So being able to take out those facts that you know aren't ever going to change, and then working with the facts that do change, it'll help you understand it better and know how to craft, how to organize your case as far as working into a theme and theory, and how you want to present that case best to the audience that you're presenting it to.
You got any suggestions or recommendations of how you might craft that path to get to your end goal? Like, are there any tips that you have done or taught your students?
Well, I think the most important thing is being very familiar with the facts of your case. Going through, depending on, you know, I think in mock trial, the students will do both sides, right?
Yep.
So at one time they'll be like the state, and another time they'll be the defense. And I think that's really, really helpful, because you should know your opponent's case as well as you know yours, if not better. So I think you need to sit down and you need to look at from both sides, what are your good facts and what are your bad facts? And there are good facts and bad facts in every single case. If there was ever a case that didn't have bad facts, that case would go away. I mean, in civil cases, it'd be settled. In criminal cases, the person would probably plead guilty. So, you know, when you go to trial on something, you're going to have both good and bad. So you have to figure out how to use those good and bad facts, because they're going to come up.
So as you try to recognize there's good and bad in almost every aspect that in a good mock trial, how do you look at your witnesses? How do you help determine what part of the witnesses are helpful and harmful to each side?
Well, the first thing I think that you need to do in any case is look at the basis as to why the case was brought. For example, in a criminal case, is it a case for murder? Is it an assault case? What are the elements of that crime? In other words, what does the prosecution have to prove? In a murder, for example, they have to prove that, you know, a human being was recklessly or intentionally killed by another human being. I think that's what they are. So, I mean, you have to look at what facts do you have that support each one of those elements in the case. In a case where you're representing the defendant, you may have a defense such as alibi. What facts do you have that support that alibi, and what witnesses do you have that are going to testify to that? And so you can craft under each one of those elements, what are the facts that support that element? And then who are the witnesses who will testify as to those facts that support? So it's the same in civil cases. In a negligence case, you know, what is the duty that the defendant, you know, allegedly violated that caused this injury to the plaintiff? What was the injury that was caused? You know, what facts do you have supporting those? So it's just a matter, if you go back and start with what the elements are that have to be proved, that's going to be more important than anything else, because if you don't prove one of those, you never get to a jury.
Yeah, great point there. So let's look at another trial element then, the opening statement and the closing arguments. How do you use those then to bookend your organization of your case theme and process?
Well, your opening statement is basically the first time that the jury or the trier of fact gets to hear your client's side of the case. Opening statements are extraordinarily important. They will basically set out a roadmap that the jury will know kind of what's going to happen, what's, you know, why are we here today? So your opening has to be truthful in that you don't want to put anything in your opening that is iffy, that you don't know if you can prove, because in your opening statement, you're basically promising to this group of people or this judge that this is the evidence that you will present. So lawyers always fall back on the "we believe the evidence will show," because sometimes you're not sure whether something's going to come up. And another element that makes it even more complicated in criminal cases is that as the state, the defendant, you know that the defendant doesn't have to testify. So they don't have to put on any case at all. So you have to be very careful in your opening only to cover your own facts and not to assume things that you think the other side may bring up. So you've got the beginning where you're telling them what their case is going to be about in your opening statement. Then you get to present all your evidence. And then your final argument is kind of like the bye-bye in a case. It's like, this is why we did all this. You know, this is why we spent time with this witness asking them questions about this. And this is why we did this. So it's a way to explain everything that they've heard, because trials don't go in a chronological fashion. I mean, you have witnesses who will testify as to things that happen all the way through the case, and you can't continue to keep calling them back on the stand so that you can talk about Tuesday and then Wednesday and then Thursday. So jurors have to take a lot of stuff and sift through to figure out kind of what happens. So the final argument is a really good opportunity to put it all together and to tell the jury what you want them to do. Because one of the things that lawyers sometimes find it difficult to do is either ask a jury for money or ask a jury to convict somebody. And those are hard to do. It's hard to ask total strangers to do things like that. So in the final argument, you actually get the opportunity to do that.
Yeah. Great points to actually think of it in practice there too. You'd mentioned a couple times about the roadmap that you're creating. And so creating that case theme is, I see it as a useful tool to organize and create that roadmap for each side. So what can you tell us about what makes a good theme for a side, or, in a trial?
Basically, a theme is either a short statement or it's a simple phrase or a sentence that kind of captures the essence of your case. Um, and it can be an easy catchphrase, an easy catchword. Basically, it needs to be easily remembered by the jurors so that it's something that you can remind them, sometimes, put it out in opening. And then sometimes you can remind them during witnesses that testify. A theme basically is about emotion, and emotions such as love, hate, fear, greed, loyalty. I mean, if you look at Goldilocks, for example, you have the lost child looking for shelter and then was hungry and had to eat what was there. Or from the other side, you have a family who went out for a walk and came back and found their house destroyed by, a marauding teenager. So, I mean, it's a theme that will resonate with the jury. It's something that they understand, because anything like jealousy, revenge, we understand that as human beings. So anytime you can tap into that emotion, that can then be your theme.
Great. And you kind of gave some examples of how you fill it throughout your whole argument and the whole aspects of your trial presentation. You talked about the opening, the closing, through the witnesses. But we all know that trials don't come easily. And so things will change and evolve, both in your preparation and, on site at the trial. So do you have any suggestions for how a team should plan for reorganization or any pivots that they might have to do?
Well, I think you have to be flexible. I think you have to go into everything in trial preparation with the idea that other than those few facts without change, everything can be different. So you have to constantly be on your toes, because when you get a witness on the stand, you have an idea what they're going to say, probably because you've taken a deposition or you have a statement or something. But that doesn't mean that that witness isn't going to go totally off in another direction and change their testimony somehow. So when you look at your theory of the case and your theme of the case, you need to make sure that you have the ability to be flexible with it, and to know that you may have to explain something that doesn't make sense, because you'll have witnesses that would disagree with each other, and you need good things that each one of these witnesses will say, but you can't totally call one a liar because you need to rely on something that they've said. So you have to be flexible in how you present that. If that makes sense, it's basically, when you go shopping for something in a grocery store, and you typically buy X brand, and then you get to the store and you're looking for your favorite whatever it is, and it's not there. So you have to try another brand. It's kind of like that. You have to be flexible in how you handle something.
Great advice there too. Is there anything that I didn't ask that you can think of as important for mock trial advisors and students to know? Some of that final takeaway about case organization and themes?
Don't ignore the bad facts. Um, like I said, every case is going to have good parts and bad parts. The worst thing that you can do is ignore the bad facts, because the other side just isn't going to forget it. They're not going to ignore the fact that there's this, big glaring hole or problem in your case. So you need to make sure that you cover that, and that you acknowledge to the finder of fact, whether it's a jury or whether it's a judge, that that that's there, and you're going to explain it and talk about it. So don't be afraid of the bad facts. Figure out how to work them into your story of the case in a way that they do the least damage as possible.
Great advice. Judge Melissa May, thank you so much for this conversation and informing me and the mock trial advisors and students that are going to watch this about case organization and themes. And great to hear your wise advice, and we really appreciate it.
I'm happy to help. You know, you can call on me anytime.
Thank you very much.
Thank you.